You have the other file?
Yes.
Yes. Mutai Kipkemoi, advocate. Mutai Kipkemoi. Next. Paul Kimutai. No, if you noticed, I found that premature, and I was not recording. If you noticed, I did not record what the advocate was saying because it was premature.
The only reason I'm bringing this up is because I believe that the application for contempt is not brought in isolation. It is not a miscellaneous application. It's an application within the main suit. So an issue then arises whether the main suit is properly in this court. Another issue also arises with regards to...
I think then what Mr. Kiplangat,
Yes, Mr. Kiplangat.
is what he said was proper,
Yes.
that there are the two, the latest application and the PO, so that it is for them now to respond, then we take directions.
Because, Your Honor,
At the moment, we have not said which one takes precedence. We have not said that.
Because then, Your Honor, I believe it would be improper to consider an application for contempt while there's a PO. The authorities...
No, and that's what you are saying. Mr. Kiplangat has put it correctly. He's filed an application today. That's the position. There's also a PO, which he has not been served with. Once he's served, we'll then take directions on which one comes first. We have not said at the moment which one takes precedence. Which one takes precedence before the other. We cannot say that the contempt one will proceed first, or the PO, or his application. Once we take directions on all of them, then we then agree which one takes precedence. Yes, I can see Mr. Kibet is itching. Yes. No, I think so they have come. There's now the second step for them to respond. That's the position. Yes, because you have laid the allegations against them, they must now respond.
There's still the fact of contempt, which is still continuing. There was some, because you look at it, those who are written orders of that year of the line. Before we proceed with anything in this case, there were written orders. And those written orders were used to preserve the subject matter of this case.
And you see, that's why
We need to
there are several issues that arise. Because as the law is, you must first prove that they were served with the order.
They have admitted. There's an application.
They have admitted in the application.
In the application, yes. The application of the same day.
And then, if they admit that they were served with the order, then they must explain why they did not comply with it.
But first they should pass that.
You see, for you to say that the speaker and the clerk must purge the contempt, the court must have a finding that indeed they're in contempt before we ask them to purge. So we are still at the preliminary stage. We have not said that they're in contempt. Yes. If they were served with the order, then they have an opportunity to explain. If you believe they did not comply with the order, then they now have to explain why they did not comply with the order. Because there might be good reasons why they did not comply with the order.
I believe that is...
Then the court now has to weigh both sides. What you are saying, what the speaker is saying, what the clerk is saying, for it to make a determination where indeed, if at all those are contempt. It is then that the court can then make an order for the contempt to be purged. But if you ask them to purge the contempt now, and the explanation has not been considered, it would not really be fair with the principles of natural justice.
We should take that application in priority, the application for contempt.
For contempt.
Because that is an application that is seeking to preserve the subject matter also.
It's okay.
Without,
Yes, Mr. Kiplangat. I think it is the same thing we've been talking with Mr. Kibet and Mr. Kiplangat. At the moment, the court has not reached the point where we are going to determine which application is going to be heard first. It is just for directions, because they have filed an application. You've not been served. You have not responded to that application. So once you file a response to the application, when you are served, when we have all applications, then we can now decide and agree which one comes first. Is that okay? Which one proceed first?
Anywhere you are.
Is that okay?
That's okay.
That is okay?
I think that's okay. So that we can take directions to know
Yes,
the issues.
because you may find that thing.
Mr. Lamyat, you can have. We will also, on behalf of the second, the first defendant, seek corresponding leave to final responses.
Your Honor, we will be seeking directions
Yes.
on whether the attendance of the first and second defendant, or the first and second cited parties in the contempt proceeding can be dispensed with. We can do virtual.
Mr. Langer?
I was hoping that was the purpose of today.
Yes.
I was thinking that was the purpose they were attending for.
For today only. But in future, they don't need to come to court.
If they are required, I think they should attend.
But for the time being,
Yes, for the
they are
time.
not required to come back to court.
Yes.
I think that is
When we
agreed.
are taking directions, that's okay.
Does the first defendant is who?
The first defendant is the county assembly.
The
But
second,
then when it comes to the application, two parties were cited.
so second
For the
defendant,
first defendant is the clerk. And
The
then
clerk
the
is not
speaker, the
present
second
today.
defendant.
She's present.
the clerk is present. Then the second defendant,
The speaker.
no, they don't need to come to court again.
Yes, that's right.
Okay. They don't need to come to court.
May you also request your Honor, for subsequent proceedings, we can have them virtually.
Virtually. No, that is okay.
Yes, that's okay.
The second defendant's application is dated 12.
It is dated 12 August 2024.
So the plaintiff to file a response to the second defendant's application dated 12 August within how many days?
14 days.
Within 14 days. And the defendants
We will also
to file further
corresponding leave.
affidavits if need be.
Yes.
Within how many days of service?
7 days?
Within 7 days of service. We don't ask for submission by this time. Or do we ask?
No, we can, we still need directions.
Directions.
That's it. So we can have a mention date to confirm filing of the safe pleadings.
Mention on
Mention on 24th September.
on 4th September.
Yes, sir.
Then we can put the writer that
24th is convenient to me.
we can put the writer that the first defendant, that is the speaker, should not
The first and second containers.
contempt us,
Yes.
or should not attend court
Yes.
unless when required. That is okay.
That's okay.
Okay. I've seen a lot of debate on social media about this case, which I think is not fair. I believe to both the parties, the advocates, and the court. So yes? Yes. If there's anything to be said, let it be said in court. Because we are now doing trial through social media. and sometimes it creates the wrong impression. Let everything be done here in court. That is okay?
That's okay.
Is okay. So on 24th of September. Yes.
It's a mention.
Mention, yes. Before the court makes a ruling. It is understood? Yes. Otherwise, we'll let the rule of law break down when we start discussing the cases in the social media. And then one side is threatening the other. I don't think that is fair. It's okay. Yes. Because if, as you say, the county government is a member of our court users committee, I'm sure you know that. The county attorney sits in our court users committee and other officials. So it really cannot say it is a war between the court and the judiciary. Things are resolved through a clear and structured way. Yes.
What we have done is that we have responded to that application.
For contempt.
Yes, for contempt. We have filed supplementary applications. You don't know the incident.
Yes.
So our suggestion is that we first proceed because there is a preliminary objection which has been raised. And the notice of preliminary objection which has been raised challenges the jurisdiction of this court to hear and determine this matter. Your Honor, if in the long run this court was to find that it did not have jurisdiction, as it were, the incidental orders which had been issued, including the ex parte order, which is subject of the contempt proceedings, will fall by the wayside. Our suggestion as the counsels for the defendants is that we first proceed to hear and determine the notice of preliminary objection which has been raised. And I wish to confirm that the second defendant supports that notice of preliminary objection. We will then subsequently, Your Honor, in my suggestion, and I hope it is convenient to this court,
Yes.
and to the counsels on record. If the court finds that it has jurisdiction to hear and determine this matter, then we go to the second application which we apply. And for the record, Your Honor, that application is brought under Article 51 of the Constitution, Section 5.
Second application, that is your application.
Our application.
No, but you see, when you
It has not been
now when you start commenting on it,
Yeah.
he is disadvantaged because he has not been served.
We've served him, but we have not seen it.
So,
So,
we
Probably
need
we
it.
could have directions then. On
No,
the-
I think it is good. Once he's been served with your